or Advocate Pile?
Thank you, Honorable Chair. There are one or two other NPA colleagues that will need to respond with regard to other issues relating to the matters in respect of disciplinary matters, etc. But before I hand over to colleagues to deal with questions, and then I'll come back at the end, and to just ask that the DG also deal with the question relating to whistleblower protection. So, Chair, yeah, no, not surprisingly, we have come under serious criticism and attack in this session today. It's understandable because of what has happened. I expected that, there will be very hard questions, and they have been. I just want to reiterate one or two things. And Chair, maybe to clarify on your last question so that when we answer them, we are on the same page. Just to understand, you asked a lot of questions about my intervention, and that things could have been different had I intervened. I want to ask for clarification. Is it the Chair's understanding that Advocate Ntalwa is one of the prosecutors still in this matter, and in fact prosecuted the matter until the end?
No, I know they had been changed.
Okay,
That's
all
why
right,
I
that's
was
fine.
asking. That's why I even said my first question was that the first team was changed and a second team was put forced by circumstances. And my view is that you should have started getting closer to the situation.
Even with the second team?
Yes.
Okay, I'll deal with that. So, Chair, firstly, let me make a few comments, responses to some of the comments that have been made. Just to say that we framed our presentation in this way, that is dealing very specifically, and we were not aware that the expectation was that we will go back in time. We understood it to be, what are we doing to address the impact and the consequences of Omatozo decision? And that is how it was framed. But what we did is we dealt with all of those issues, the three key interventions. But the reason why we also included some of a fraction, a small, minute fraction of the really good work that is being done by prosecutors across the country, who I would ask not to be demotivated by this session. The reason why we included this, it wasn't to get any applause for it. It certainly wasn't, to sugarcoat the devastating impact of the Omatozo decision. That was not the intention. The intention was really, we understand that the Omatozo decision has dented confidence in the criminal justice system. And the reason why we thought it's important that we deal with these issues is that many of the honorable members raised the fact that people lose confidence in the system. Victims may not come forward. And the reason why we included all of this is really to appeal to victims. Don't throw the baby out with the bathwater. This is a very important decision. It has had a devastating impact. And more than that, the victims, of course, feel it more than anyone. As the NPA, we feel it because of the impact on the institution. And so because of that, we wanted victims to know, which is what I said in my opening address. We are saying this because understand this is one case, but a very important case. But please don't lose faith in the system, because there are so many good things that are happening in the system. And that if you happen to be a victim in the future, please don't be discouraged by this one decision. Know that you will get the necessary. Firstly, know that we are ensuring accountability, and we are, with regard to the three interventions that I mentioned, but also know that you will get world-class service, which victims across the country are getting in many Tutuzela care centers, but also there's many support services in places where there are no TCC. So I really want to urge that the idea was not to sugarcoat. this has been a devastating decision. But it's really to say to victims out there, please don't underreport. You do nothing wrong. Come forward and report these matters, because you will get the services that you need, the support that you need, whether it's legal, psychosocial. You will get these services to make sure that at the end of the day, justice prevails. And that was the only reason why we did this. It is not to receive any applause for it, but to really give confidence to the victims that don't lose faith in the system because of this one case. There's a lot of good work and hardworking prosecutors that will support you and help you get through to this process to become a survivor. So that was the only reason why we did that. And we still think it was important to have done it. We would appreciate perhaps if the portfolio committee wants us to come and do a separate presentation on all of those things, which it was the tip of the iceberg today. We are happy to do that, to build more confidence in the system, which has been badly dented. So I think I'm going to, at this point, call on perhaps Mzanyati, can I call on you? Should we go to Barry Madolo first to deal with, perhaps Barry, I think it would be best if you deal with some of the matters, and then we'll look at Mr. Madolo. Chair, if I may just also address one of the questions that the chair raised about the appeal process. Just to be clear that the decisions to prosecute or not to prosecute or to appeal a matter are legally within the prerogative of a director of public prosecutions, not the national director. But you are absolutely correct in terms of the section that you quoted. They work under the control and direction of a national director, but it excludes prosecutorial decision-making. That being the case, when there was an acquittal in this matter, I contacted Barry, Advocate Mr. Madolo, immediately, and respecting the fact that he is the decision maker on appeal. And unlike previous national directors who blurred this line and created lots of problems in the National Prosecuting Authority, I have been very strong in holding the line that as DPPs, I will not interfere in your decision-making processes, but insofar as ensuring all the things you mentioned, the support, ensuring that cases, their proper risk management that we've now put in place, there are a lot of lessons that we've learned from this. But as a national director, I've got to make sure that a prosecution has the best chances of success. And what do I need to do to hold DPPs accountable, as well as to give them the necessary support in cases? In this particular case, once there was an acquittal, I contacted the DPP immediately, and I said to him, we are going to set up an outside team of prosecutors from outside of your division to look into this matter, to help you, because ultimately it is a DPP's decision, to help you make a decision on appeal. Not just people from outside, the best prosecutors in the country from outside of the Eastern Cape, but also we will get senior counsel from external to the NPA to help you make this decision. This was something the DPP supported, but it was something that I had said must be put in place, because given the credibility deficit that the Eastern Cape was facing, it was important. And this is not to cast, in fact, the lead prosecutor in this matter had to work with the internal team because, they needed information, etc. So he worked with them. But apart from that, it was a big external team. So that was put in place. The DPP supported it, and we moved with that. So in this particular case, the the red flags were certainly raised, but before the change of the team. After the team was raised, as you heard the DPP, there were absolutely no red flags that were raised. The issues of cross-examination, etc., I would think surprised most people, including the DPP, when the judge mentioned it. So it's not like whilst the new team was proceeding, there was any need certainly for the national director to intervene, because there was absolutely no red flags that were raised by the DPP about. But yes, there were problems with the red flags raised with the first team. And we've explained what happened, but to give a little more detail if we need to. Just to mention that the application for the mistrial, and Barry, maybe you can help me out in terms of the dates, because I don't have everything right in front of me, but I think it may have been in my notes, I'm not sure, but was in 21 or 22, where the application for the mistrial was brought, specifically on some of the grounds that you mentioned, Chair, that there was the suborning of the witnesses. And it will be useful to read the judgment in that matter, because the application was not granted, because the judge found in that case that the conduct of the prosecutors did not amount to a mistrial. So those matters that were now raised in the main trial, and again, I find myself very constrained, because as the prosecuting authority, we argue and we legally criticize opinions and judgments in our papers. We don't do it in the public. Out of respect for the rule of law, we do not do that. And this puts us in a very difficult situation where I do not want to criticize publicly, but so when we don't give, we can't explain everything. There's a gap in the understanding. So to be very clear that in that judgment, the application was not granted, and the issues that you mentioned were actually dealt with there. But the judge in the final decision certainly raised that as some of the reasons why she potentially could not decide to what extent the witnesses had been influenced. Now, we have views on that, but I'm not going to say anything more about it because the matter is under appeal. But I'm going to call on Advocate Mthunzi Mahaga, who is the head of our Legal Affairs Division, who is managing the process relating to the appeal, to answer some of the questions relating to the reasonable time issue, etc., which the chair raised. But before I do that, I'm going to call on Advocate Bonnie Curry Gamwell to deal with some of the issues that have been